SJC-11964, Commonwealth v. Manuel Antonio Mercado.
Good morning, Mr. Faulkner.
Good morning, Mr. Chief Justice, and may it please the court. The central question in this case, as the amicus has observed, is a very narrow one. It is whether pleas that occurred between April 24th of 1996 and April 1st of 1997 are subject to the retroactivity of Padilla versus Kentucky.
We made it clear that it was April 1st, 1997.
In Clark, it was made.
And Sylvain as well?
And in Sylvain,
Okay.
That's correct.
And it's not retroactive under the United States Constitution, right?
It's not retroactive at all under the United States Constitution. However,
No, I'm sorry, when you say retroactive, you're referring retroactive with regard to certain types of cases, specifically drug cases.
drug cases, it would be,
To those cases which the AEDPA,
correct, and that would be,
non-discretionary relief.
that's correct.
So it would not be all cases.
Well, it would be many cases. It would be drug cases, weapons cases, any national security offenses, and crimes involving moral turpitude, which had been greatly expanded by AEDPA. As the amicus discuss, I think that's section 435 of AEDPA. But this case in particular was a drug case.
Well, think of the justice in this case. It's a little strange. He's arrested in 1990. He flees the jurisdiction, comes back in 1996, pleads guilty twice, late 1996 and early 1997. And now, I don't know, what, 18 years later, you say do-over?
Well, he was served a notice to appear in August of 2014 by immigration, indicating that he would be deported as a result of this conviction. His immigration attorney, as she testified, advised him that it may have consequences of deportation, but that she never would have advised him
Well,
that
it
he would
didn't
be
for
deported.
18 years. So may have was actually pretty good advice, since it took 18 years for anything to happen.
Well, that's not simply the law, and it was inevitable, and it did.
They didn't
eventually
have
come
to do
pass.
this. Did they have to do this?
Oh, they did.
Why didn't they do it before 18 years then, if they had to do this?
Well, I can't explain why it is that they didn't. It didn't come to pass, but the law mandated his deportation or his removal. Section 440D provides no avenue of relief from deportation or removal, and that's why he actually was removed. The order of removal is contained in the record appendix. The fact that, for whatever reason, immigration didn't take him into custody has never been one of the factors that was considered, and indeed, one of the reasons why it was made retroactive back to the IRIRA, which is the Illegal Immigration Reform and Immigrant Responsibility Act, was that there were people who were being removed as a result of pleas during that time frame. I think what's crucial here is that the primary, as was testified by the attorney, that the primary motivation for this plea, and it's in the transcript at pages 21 and 22, the primary motivation was to try to ensure that Mr. Mercado could stay in this country.
If the judge, the motion judge, had said that I credit trial counsel's testimony that the defendant told me he consented to the search, and I discredit everything that the defendant had told me, if the judge had actually made those findings, would you be here?
Well, I think it would be a different story depending on if the judge had made specific factual findings. But even the consent itself, it's not clear that that would have obviated a motion to suppress. Indeed, there certainly is evidence from the police report that this would have arisen as something different than a simple consent search. In other words, that Mr. Mercado had been, at the very least, detained at the time of the supposed consent.
Was there a booking slip in this case that revealed that the defendant had 2 coats? Because I take it he said that a couple guys ran by him and dropped a coat, and he picked up the coat.
That's correct.
And this was in the winter. This was what, in February?
Um,
Assuming he was wearing a coat. I don't know that. But does
That's
the
a-
booking
that-
slip reveal whether there was 1 or 2 coats at the time that he was brought to the station?
I'm unsure, Justice Spina, of
Okay.
the answer to that question. And I don't believe there's a booking slip. Certainly, it wasn't admitted during the hearing as an exhibit. So not within the record that was before the motion judge.
Okay.
And going to the idea,
I'm sorry, going back to what you say is the proper advice, it sounds as if the proper advice was ICE, or maybe back then INS, can seek to deport you, and if they choose to do so, there's nothing you can do to prevent it.
well, the court has made clear in Sylvain and in De Jesus that the proper advice is that deportation is inevitable.
So you would say it makes no difference whether you're talking about IRIRA or however you say it, AIDPA, it's the same advice.
That's correct. Under the Anti-Terrorism and Effective Death Penalty Act, AEDPA, the correct advice is that deportation was practically inevitable. In other words, the reason why, and going back to Sylvain and Clark, Padilla is the case where the United States Supreme Court held that it was AEDPA that made deportation practically inevitable for a wide class of...
Did they really? I mean, they referenced, as I have Padilla in front of me, Congress eliminated the Attorney General's authority to grant discretionary relief from deportation, 110 Stat 3009-596. What's that?
That is...
IRA? IRIA? Isn't that the IRA Act?
What IRIRA, there was, before AEDPA and before IRIRA, there was a section of the Immigration and Nationality Act, that was 212C, which allowed the Attorney General to grant waivers of deportation, and it had been granted in a substantial percentage of the cases. AEDPA Section 440D eliminated those waivers in drug cases, weapons cases, cases involving national security, and cases involving crimes involving...
But what you're...
And by that, I gather, said the AG may not, under this authority, do it for this category of people.
That's correct.
But
So
212C survived.
212C survived, but only really for a narrow class of cases.
And then in IRA, 212C was
simply
dropped.
eliminated. That's correct. And so, although 212C survived as an artifact, the enactment of AEDPA on April 24th of 1996, it didn't apply to a wide class of legal permanent residents who had been convicted of certain crimes. And so...
So your point is those people are in absolutely no different circumstances than somebody after April of '97 with respect to those crimes or any others.
That's exactly correct. So that Mr. Mercado, the time when Mr. Mercado's crime mandated his deportation was April 24th of 1996. Nothing really for him changed on April 1st of 1997.
Okay, so let's assume you are right as to that point, and as best as I can tell from the Commonwealth's brief, it agrees with you, but we'll find out from Mr. Zanini in a moment. He says, though, the judge, by denying it, essentially rejected all of the witnesses, and therefore we don't need to remand it because the judge already essentially discredited it. What's your what's your position as to that?
Well, so to begin with, the Commonwealth does now before this court, and I'm reading directly from page 6 of the Commonwealth's brief, that the defendant was entitled to accurate and correct advice from his attorney that were he to plead guilty to the charged crime or the lesser included drug offense, his deportation was mandatory because he was not eligible for a discretionary waiver.
But that was a different position than what they took before the motion judge at the time.
That's exactly
And because there was
correct.
nothing in the findings, could that have been the position which the judge took? Oh, well, that's easy. It doesn't apply.
Yes, Justice Duffy.
There's an argument about this.
That's exactly the point. The Commonwealth argued, and this is in the transcript at page 56, it is the Commonwealth's position that Padilla does not apply in this case. They took the same position in their written opposition, and they also took the position both orally and in their written opposition that the 29D warnings were sufficient, which this court has
Padilla
clearly
doesn't
held.
apply because this wasn't an IRIRA case, because it was before IRIRA.
That's correct. So the Commonwealth basically argued to the motion judge that because it wasn't retroactive, you don't have to get to the issue of credibility. The proper advice wasn't necessary. It didn't have to be given. The findings in this case, in sum total, are 42315 after hearing denied, and that's in the record at page 5. There's no way to know whether the motion judge denied this motion because Padilla wasn't considered to be retroactive, which under the law of this court it wasn't at that time, or whether he discredited the testimony of any of the witnesses. And
I think back to the judge I clerked for who once told me that word denied, it says so much.
Right.
But you're saying it doesn't say enough here.
That's correct. In other words, Chief Justice Gantz, there is no way to determine from this record whether there have been credibility findings made or whether there has been a legal determination made. And when that's the case, the court can't simply assume that the trial judge discredited the testimony. Now, the other thing that I would point out is that the testimony of the defendant, well, you know, whether the judge views that with skepticism and discredits it is one thing, but the testimony from the attorney was pretty clear that it was her idea to try to keep him in this country, and that was credited, that also was supported by the fact that in her file, and she testified to this, in her file she had Mr. Mercado's legal permanent resident card. And it's also supported by the fact that there was the lesser included plea. So I think the idea that her entire testimony was just wholesale discredited by the motion judge is, first of all, it's not supported by the record, and secondly, I think it's pretty hard to believe that the entire testimony of the attorney would have been just simply thrown out by the motion judge in that case.
So if you're right, we remand it, and then you would have the burden of proving the second prong.
Well, that's correct. I think it just needs to be remanded for factual findings.
Right, but then you would need to prove that
That he would,
he would have done something differently had he received the appropriate advice.
I think that's correct. Either that there were special circumstances or that he might have been able to get a better plea.
one
or
of those
that-
three things in Clark, or whichever one, yeah.
That's correct, or that he would have been able to, that he had an available defense. Now, the other point that I'd make is, in terms of the available substantial defense, is his testimony at the hearing was that this wasn't my coat, it wasn't my drugs. Now, whether the motion judge believed that testimony or not, it doesn't go to the fact of whether that actually would have been a substantial ground of defense. That would have been a question for the jury at a trial. It's not a question for the motion judge to determine whether I believe this defense would have been successful.
Wait. So anytime someone comes in and says, oh, by the way, I didn't do it, and that's what I would tell the jury, that's enough? That undoes everything?
Well, his
That's
testimony.
a substantial ground for defense. I didn't do it.
Well, in the circumstances of this case, the element of the crime is knowing possession of a controlled substance. And his testimony is, I had it in my hands. I had the jacket in my hands, which had the drugs in the jacket. I didn't know there were drugs in the jacket. That's testimony that he could have presented to a jury, and if a jury accepted
You're
it.
saying that alone means that there was a substantial ground of defense, therefore,
Isn't a better reading of that, it's like that that the defendant had a good motion to suppress, which he didn't bring because he decided to plead?
Well, Justice Botsford, is a separate issue. I think there was substantial grounds for a motion to suppress, and he needn't prove that the motion to suppress would have been successful, only that there was a reasonable likelihood of success.
But if the judge were to credit trial counsel, who said that, according to the best of her memory, the defendant said that he consented to the search, and then some discussion about, I got a good plea deal here for you. I mean, if the judge were to find that the defendant made a knowing decision to take a plea in this case because he had a good deal, doesn't that create a huge problem for you?
Well, first of all, that goes back to the problem of the fact that the reason for the plea deal was to try to ensure that he could stay in the country, so it wasn't such a good plea deal after all. But secondly, his reasoning as opposed to whether there would have been an available substantial ground of defense are separate inquiries, so I don't think one cuts against the other in the way you suggest.
All right, thank you.
Thank you, Your Honor.
Morning. May it please the court. John Zanini for the Commonwealth. I think there's three issues before the court. The first is the question of whether under the 1996 statute, the Anti-Terrorism Enforcement of the Death Penalty Act, correct legal advice required telling the defendant that he was subject to removal and that cancellation of removal or waiver of removal was no longer possible. The second question is whether the defendant's prior convictions, which he picked up between the date of his default and the date of this plea, would be admissible to assess in the totality of the circumstances whether a reasonable person would have pled in this case.
Now, those were excluded below, weren't they?
Correct. The judge did exclude them. The attorney made a proffer, in essence, that he said that she explained. This is on page 50 to 51 on the transcript, where she started to ask the defendant about his convictions in Florida. He testified he was in Florida from the 1990 through 96, which is the time frame on default. And so she started to get into his convictions in Florida. It was objected to. She said, well, it's a Padilla motion. We're discussing the fact he's deportable if he is found to be guilty. So it's a little awkward the way she phrased it, but I think what she's saying is he's already subject to deportation for these convictions in Florida, so that this particular conviction when he pled guilty didn't really put him in a worse position.
Is that issue before us?
Well, I think that if you're going to remand the case, that you need to reach that issue, because if there's going to be, the Commonwealth could ask to reopen the evidence and put that in, because it's properly in front of the judge to consider in the totality of the circumstances whether this defendant would have pled guilty anyway.
Well, are you also saying that it's admissible on the question of whether he was correctly advised?
Yes, or at least his state of mind. He could have been advised in Florida properly, depending on the dates of different events and different convictions. Or in another case, you can foresee a case in which a lawyer in case number one gives him 100% accurate advice on a drug case, and then he's pleading a year later on another drug case. He already knows he's subject to deportation. So I think that these convictions, depending on the timing of events, are going to be very probative of the question of special circumstances, prejudice, totality of the circumstances, and what people's understanding of their exposure is.
But that's prong two. Justice Spina's question
Correct,
was, would it
correct.
go to the first prong of whether the attorney's advice was incorrect?
Well, I understand that the attorney's got a separate duty and a separate question there. So the lawyer may, in this case, I mean, we don't know, but I can foresee a case where the lawyer might testify, yeah, I was aware of his prior convictions, he brought it up, we discussed it, he told me I'm already subject to deportation, so I told him, well,
I mean,
this...
why did she object to it? If
No, the defense lawyer objected. The
yes, what I mean,
prosecutor
why did the defense lawyer object to it? If she must have understood what the consequences were.
This is at the motion for new trial hearing?
Yeah.
Where the motion for new trial attorney objected to the prosecutor asking the
Oh,
defendant.
I see. I'm sorry.
So, of course, he's trying to keep out
Yeah.
highly probative
Okay.
information, which will, reveal that he's already subject
Of
to
course.
deportation. I mean, well, that's what lawyers do. That's their,
But going, just to make clear, I gather you do concede that the proper advice here is that even though we had said before that the key date is whether it's after April 1st, 97, that you agree that the proper advice would have been that it applies post EDPA 4496, at least with respect to those crimes for which the Attorney General was denied the ability to exercise his or her discretionary authority.
yes, but I'd like to make a couple of quick comments on that. I mean, I can understand why the prosecutor in East Boston District Court and the East Boston District Court judge followed Clark and were bound by Clark. So I don't think that should take any,
Yeah, Clark and Sylvain are very clear. It's
Yes,
April 1,
yes.
1997.
Absolutely. So, however, as I read Padilla and St. Cyr, which Padilla discusses, 1996, on page 363 to 364 of Padilla, which is 559 U.S. 363, 364, the 1996 effective date they're talking about has to be EDPA, because ARERA is a 1997 effective date. So there's also language in Padilla and, about a 15-year sort of reach back. So in 2010, the U.S. Supreme Court is saying at least 15 years ago there was a duty to give proper advice, which would put us in 1995. And this court also in Clark relied on the national standards of 1995.
So I'm sorry, I didn't go back and look at all of them for this, but so you're saying that Padilla is saying more than one thing? Or what do you?
Well, no, I'm saying
So
that...
97 isn't the year?
Well, there were two different statutes. They were both enacted in 1996, one effective April 24th, I think, 1996, one effective April 1st, 1997. Both of them impact the immigration status of individuals convicted of crimes.
Right, and particularly in this case, as to drug offenses, as of April of '96, there was no longer a cancellation or waiver of removal discretion
right.
for the Attorney General.
Right.
So as of that date, this became sort of a
The same, the
mandatory
functional
removal.
equivalent, I mean, right.
Correct, and I didn't see, I can't articulate for you a reason to reject the Commonwealth's concession and find that this was not ineffective. And the reason is quite simply this. Until at least 2001, with the St. Cyr decision from the U.S. Supreme Court, it may not have been clear to attorneys that the effective date of the lack of a cancellation or waiver of removal was dependent on the date of the plea rather than the date of the offense. So the U.S. Supreme Court in St. Cyr in 2001 makes it clear that it's the date of the plea that controls whether or not the advice had to be there's no longer a waiver. So you could find under the first prong of ineffective assistance that an attorney in 1996 would not have been clear that it was the date of plea rather than date of offense that controls. And the case from the First Circuit that I cite in my brief, Santa Cruz Buccelli, has a litigation history, and that's also, I believe, in page 6 of my brief. That First Circuit case had a litigation history from 1996, right after EDPA, that person pled guilty, and the case went through from the immigration judge through the process to the First Circuit for 10 years. And in 2006, Santa Cruz Buccelli, like St. Cyr obviously said, okay, the effective date of the lack of waiver is the date of the plea, not the date of the offense. But in 1996, Santa Cruz Buccelli raised in the immigration court and pursued it all the way up through the First Circuit Court of Appeals, that argument. So it could have been unclear under the first prong of ineffective assistance, where the ordinary fallible lawyer might believe there's still the possibility of waiver, cancellation of removal, even though AEDPA had been enacted. So that argument is out there. You're not bound by the concession. You can either draw the line at 2001 under the first prong of
But didn't we already draw this line?
well, that's why I didn't think that was
Okay,
the
all right, I'm
best
just-
argument in the world to make. It can be
Okay, fair
made.
enough, fair enough. All right.
It's a fair argument. I just didn't
Yeah.
think it would actually prevail, so.
Okay.
The next question, though, is, so we've talked about the prior convictions. I want to talk briefly about whether a remand is necessary, and that is on the issue of prejudice. So on the issue of prejudice, there are three prongs: whether there's a substantial available defense, whether a better plea bargain could have been had, and whether any reasonable person would have gone to trial. Not this subjective defendant, but a reasonable person. On the better plea bargain idea, I don't think that's here. So in the bench session, he pleads to the possession with intent charge, and he gets a sentence of, I believe, a year in the house, suspended for 2 years with probation. He then goes to the jury session over in Chelsea, and in front of Judge Agnes gets a better deal, which is he pleads to the lesser included of straight possession with a year in the house, suspended to 1 year of probation. So with 300 bundles of heroin in his pocket, arriving at Logan Airport, getting off the Trump shuttle, I don't think that he could have gotten a better deal than the lesser included offense with 1 year of probation.
Excuse me, Mr. Zanini, is that something that we decide ahead of the remand, or do we say it's an error of law not to have advised him, let the judge figure this out, particularly since there are no findings in this case?
So I think under Clark, this court did reach the prejudice issue directly based on the record, because there was a hearing, and I think Clark was an affidavit. Here you have the full evidentiary hearing, so I think you can do it as a matter of law.
But we
and
don't
say-
have findings, though.
Correct, but you don't need them because you have all of the facts. So if you have all of the facts, I think you can apply the law.
So how do we know who
to
to
those
believe?
facts.
How do
Yeah.
we know who to believe?
Yeah, which are the facts?
Well, you know what the plea was, absolutely. It's clear on the
Okay.
record. There's a docket. The docket, you can look at the docket and say, here's what he got in the bench session, here's what he got in the jury session. So as a matter of law, could you do any better than this?
But how do we know that, your brother's arguing that we don't know whether the judge made the decision, the terse denial on a question of law, which was that Padilla didn't apply here.
I agree. And then, so I'm getting, the question is, are you going to remand? Do you need to remand? And if so, to decide what? And how do you decide that? I think on the could a better deal have been had, you don't need to remand that. You can say, no, there's no better deal that could have been had. Look at the police report, look at the testimony that the
What
judge
about special
took.
circumstances?
So the special circumstances, can I just touch
Sorry.
briefly on the substantial available defense, the consent issue? So the lawyer testified, she was very forthright, and she said, I have in my notes that he told me he consented to that search. And then she said, so I couldn't file a motion to suppress because I couldn't even get him to sign an affidavit saying this was not a consensual search. So you have a very forthright ethical lawyer who says, I don't have a motion to suppress. He can't file an affidavit saying he didn't consent to the search. We're done with the suppression issue. There's no substantial available defense. He's got 300 bundles of heroin in his coat pocket. So Your Honor's question about the special circumstance would a reasonable person have gone to trial? And what the court said in Lavrenenko in 473 Mass is that you have to look at this in light of the totality of circumstances. So the defendant and the lawyer testified that he'd been in custody from the time of the bench plea until the time of this jury trial plea, and his concern, I think, was getting out of custody. He was in custody only for 10 weeks, but she said one of his concerns was he wants to get out of custody, and that's on transcript 22, page 22, line 6. She also did say she was trying to minimize the immigration consequences with the plea to the lesser included and the probation. The defendant, however, interestingly, in his testimony, he denied that she ever spoke to him about immigration consequences. And that's at pages 45 and 47 of the transcript. He denied the conversation ever happened. The other issue, when you're looking at totality of the circumstances, would be the overwhelming evidence that he's guilty of this offense, the 300 bundles of heroin in his coat pocket. The other factor would be, I believe, whether he's going to get any better sentence. Should he reject the bargain and go to trial? Should he just take the deal? I think that's part of the totality. So I think based on the overwhelming evidence, the lack of a consent, search and seizure issue, his fact he's in custody and wants to get out, you can say there's no special circumstances, just on the facts as established right here
Well, we
in the
haven't actually even
testimony.
touched on the special circumstances, so you would consider some of those other factors, but against the special circumstances, if they're present in this case, that make it different for someone who is going to be deported.
Yes,
And
but
then you'd have to look at those circumstances as well as whether that was being considered during the plea discussions, which according to your incredibly credible and forthcoming attorney,
right.
said they were.
She said it was a factor,
Right.
and the defendant denied in his testimony that she ever addressed it with
So
him.
this should be for the judge, right?
Unless, if you look at the facts that are established on the record, I say you can decide that there are no special circumstances. I think the court did it in Clark on affidavits. You can do it here on a
But no,
transcript.
I've not gone back to the transcript. Is there anything about the defendant speaking about the intensity of his desire not to be deported?
No, in fact, it only comes up on redirect. He doesn't even address it in his direct testimony. Then there's a cross, and then on redirect, his lawyer asks him, if you had known about the deportation consequences, what would you have done? Would it have mattered? And he said, yes, I would fight the case. That's what he said. Unless the court has further questions, I'll rest on the brief.
Okay, thank you.
Thank you.